Hey there, Natalie Teston, family law lawyer in Northeast Georgia here. I wanted to talk to you today about guardian ad litems, what they are, when do we use them in cases, so that you can sort of know what to expect if you find yourself in a case where one has been appointed. So first, what is a guardian ad litem? A guardian ad litem is an attorney that is appointed by the court, or the parties can agree to the appointment of one, who conducts an independent investigation, tries to help our judge sift through the he said, she said, and must present a recommendation of what is in the children's best interest to the court and to the parties at the end of their investigation. So, what is all involved in their investigation? Well, guardians, by their appointment order, essentially get a full release to all of the parents' medical, psychological records, and also the children's records, including school records, perhaps even any defects records. So that appointment order is very broad and gives that guardian a lot of power, so that they're not always asking, "Mother, may I?" to get information. They can just go directly to the source, show their order, and get what they're looking for. So guardian ad litems surely talk to parents, talk to the children involved in the case, probably more than once, depending on the case. Usually guardians try to build a rapport with children so that they actually open up and tell them what they think, what they feel, what they like, what they don't like. Talk to the parents, children, grandparents, other family members that are heavily involved with the children. They can talk to school teachers, therapists, doctors, extracurricular coaches, neighbors, friends of the children, whoever may be relevant in a particular case. That's who a guardian is going to talk to. So that's the who. What else do they look at? The actual documents. When I am a guardian, a lot of times I will ask to see the parents' communications between each other, maybe for the last year or 6 months of time, just to try to get a flavor of how they co-parent, what the big issues are where they disagree, where are the shining examples of where they actually agree and get along well, to try to harness that going forward. Guardians can also look at parents' medical records, parents' psychological, psychiatric records, criminal records, you name it. Guardians can also make recommendations throughout the case. So, in a case where there are allegations of, let's say, substance abuse, guardians can ask for random drug screens of the parties, can ask for random drug screens of people living with the parents. So, of course, that would not be a court order, right? The guardian is not the judge, but the guardian could include and would include in their report, "I asked Joe and his wife to go do a drug screen 3 different times during this case, and he refused, and his wife also refused every single time." That gives me some concerns, right? And guardians can sort of act to mediate minimal issues, right? Try to help parents reach a middle ground on things that may come up during the pendency of the case as well. So how do you get a guardian appointed? Well, there's 2 different ways. One is where a judge, just by reading the pleadings, can tell a case is crazy hot contested, or after maybe hearing a limited hearing, like a temporary hearing, realize there are some serious allegations both ways here. I need my own independent investigator, someone that reports directly to me, to ferret out all of this and to give me a recommendation that I can really feel good about. So one way is the judge just orders one. "Hey, you guys, this seems crazy. I'm going to appoint a guardian ad litem to help me figure this out." And typically the judge will say, to the parties, "You guys try to pick the specific guardian, and if you can't, let me know in 3 days if you don't have an agreement, or 5 days, and we'll pick one from off the list of guardians that practice in this area." Another way is for the advocates in the case, the attorneys for the parents, to realize this is a wild case. Maybe there's a situation where we can envision everyone wants to bring the children to court to testify. Certainly that is not a favored move by anybody. Why don't we just get a guardian to investigate, try to give us some clarity here? This is one that could go crazy and get hot and wild, but before we go there, can we pump the brakes and let somebody that we trust do an independent investigation and report back to us? Maybe that could get us something where we can mediate and be done with this case without all the fireworks and toxicity that is many times involved in contested child custody litigation. So again, 2 ways, right? Either the judge can order one without anyone asking, or you guys can agree. Or actually, there's a lot of cases where one party really wants one and one party really doesn't, and the party can file a motion. Dear Judge, please appoint us a guardian ad litem. For all these reasons, we think that one is very necessary and appropriate here. I would say as a general rule, judges do like guardians. Again, it's just an extra layer of protection for their decisions in this case, that they've had somebody, their own boots on the ground, to go in these homes, right? To do the smell test at parents' homes, literally get that sort of level of knowledge. That's rare for judges. Think about that, right? Judges typically hear 4 to 12 hours of evidence from the parents. It's rare they get to meet the children. Sometimes they see a photo of the children. You know, they're making decisions for people that are lifelong, have life-lasting consequences, and folks that they've never really met before. And they're making that decision based on hearing the worst thing about the other parent for many hours on end. It's not the best situation, right? That's a tall order of our judges. And so having a guardian ad litem on the case, someone that is unbiased, is neutral, has no dog in the fight, if they represent anybody, right? It's the court understanding the best interest of the children here, that literally writes up a recommendation for that judge. And so there can be no he said, she said on this. The guardian reports directly to the judge and will testify at the hearing about their report, their recommendations, and the reasons why, and the things that they've looked into. A lot of times the guardian ad litem does more work and more investigation, speaks to more witnesses than even would come to testify, which can also be a good reason to use one. It's costly and irritating, right? To go subpoena 20 people, ask them to take off work, hang around the courthouse for a day just waiting to be called. And when witnesses take the stand in court, right? You got the court reporter there, all eyes are on them, the judge is in the big black robe. It's a frightening situation. Not everyone's a public speaker. So you may have the right person there at court, but they may not be giving you the best information because they're nervous, they're scared, they're like deer in headlights, they forgot what they were even saying. You may get a better quality of information from that person just by letting the guardian call them on the phone, right? And just say, hey, can you just tell me about this family, what you have observed over the years? What have your interactions been? Do the children seem as bonded to one versus the other? Have you ever heard them fight? Have you ever heard the children, act a certain way or see anything that's worrisome? Have you ever observed the parents when you thought they may be under the influence of something? Those kind of questions go over a little bit better in a less adversarial, calm manner outside of court, of course. And so the judge also knows that sometimes not only can a guardian get in touch with more people because we have more time than just that one specific court date, but also sometimes the quality of the information that you get is better too. So you got quantity and quality going there. And for that reason, it's very difficult to go contrary to a guardian ad litem. Typically, if a guardian sides one way and you want to fight against it, you can do that, right? It's not like the guardian's the judge, right? But it's not super likely to work because that judge knows that that's an unbiased person that has done a great deal of work in your case. The cost of a guardian ad litem is also something that we're asked when we're discussing whether to have one appointed in our cases. A guardian's another lawyer on your dime, and for that reason, their hourly rate is lower than most times what you'll see from parents' lawyers. Typically, they charge between $150 to $250 an hour. Usually that's split equally, at least initially, by the parties to, again, give the very clear indication that they are unbiased, right? At the end of a case, though, it's not so uncommon to hear one party ask for a reallocation of those funds. If their income is lower, Judge, I shouldn't be hit with 50% of that guardian bill. I only make 20% of what this other parent makes. Or, Judge, I gave this guardian very limited, very specific laser-focused things to go investigate. I'm looking at the guardian's billing. It looks like they were just on, going down rabbit trails for weeks on end, which increased our fees, but, that was all the other parents doing. That had nothing to do with me. I know that stuff was nonsensical, but the guardian had to look into it because allegations were made. And you'll see in the report, there was nothing there, but it cost these parties a ton of money trying to figure that out. So you can ask for a reallocation at the end of the case. So guardian ad litems are being used more and more frequently, as you can probably imagine, especially in cases where children are old enough and articulate enough to tell us their thoughts, their feelings, what they've experienced, but maybe not old enough under the statutes to really indicate a preference that's legally actionable by a judge, right? So that's going to be children that are anywhere between 6 to 12 years old, would be old enough to tell us what they think, have, good articulable reasons for what they think, and it to be important to them to have a custody schedule that matches their goals. Some, if not all, right? So I play guardian ad litem in many cases. I always say it's the most rewarding work that I do, to really be able to be unbiased and to report directly to the court. I feel like I have a lot of impact in those cases, but it's also the hardest work that I do because I have to know both sides of the case with laser focus, right? And it calls on me to make some credibility determinations when I'm drafting up a recommendation. And I tell folks when I play the role of guardian ad litem, please tell me what's in your heart, what's in your mind. I don't know you guys, and I can't just say, "Woo, this one's tough, pass," right? I am court ordered to issue a recommendation, and I'm gonna do that, by golly. So if it's junk in, junk out, and this whole process has been for nothing. So tell me the things that I need to look into. That's why we meet with the children several times to try to establish a rapport, see how things are going, see if they can open up a little bit more, because that's difficult for children to speak to strangers about very intense and personal things in many cases. But it's something that we enjoy doing, and it's very necessary in a lot of cases. A lot of cases have completely turned around. The judge was finding for this parent, a guardian got involved, actually did some investigation. A lot of lies were brought to the surface, a lot of fraud, a lot of whatever it is, substance abuse, things that were hidden, and then all of a sudden, the case changes trajectory. So cases where you would want a guardian ad litem. Who are those folks? Again, folks with children that age that they're a little too young to come into court and testify or sign an election affidavit that really has a lot of oomph, but old enough to still tell us what they think and feel. Obviously, those cases. Cases where you've got evidence that is not necessarily going to be easily admissible. The guardian can consider the quadruple hearsay and look at text and records that aren't authenticated, right? They may reduce their value in their mind, but they can still look at it. They can look at stuff that happened before the last order, which under our code, that would be inadmissible evidence, right? At the hearing. So sometimes we use guardians to say, look, we've got a lot of evidence, but a lot of it can just get knocked out at court if the judge is ruling real tight on the rules of evidence here. At least let's get a guardian who can look at the admissible and inadmissible, and at least we have a recommendation that looks at it, right? Somehow we've sort of inserted that into evidence when it was iffy before. And also cases where perhaps it's very contested, right? You guys cannot agree that the sky is blue, but you don't want to go to toxic litigation and ripping each other up for days on end. We want to see if we can have somebody sort of do an investigation, report back to us, and see if we can settle this thing quickly and amicably. Those are cases where you would want a guardian ad litem, because even though guardians aren't cheap, they're a lot cheaper than a 5-day contested custody hearing and 50 depositions of random witnesses here, there, and the other. I mean, that is not holding a candle to those fees. Cases where you don't want a guardian ad litem, maybe where you have a child that's old enough and that's firm enough that's citing for your particular parent, right? Why would I get a guardian to mess this up? I've got the killer evidence right here in front of me. It's the child. The child really wants this parent. Maybe also a case where you want to move fast, right? That you just need to get into the court. The evidence you got is good. It's going to be admissible. A guardian slows things down because they've got to do their investigation. They're not going to just shoot from the hip, right? They're court ordered to do a thorough investigation. So in a case where you want to move quick, you may not want a guardian. Cases where there's not a lot of money to go around. If your client is struggling to pay you, let's not get another lawyer on the case and increase those fees that they're going to be paying. That could be another reason. And maybe when your own house is not clean, right? When you know, look, my client's psychological records probably aren't coming into evidence. They have psychotherapist patient privilege. Good luck. And there's bad stuff in there, right? Or lots of prescription drugs or psychiatric records that are not good, or defects records that are pretty tightly locked up. maybe you don't want a guardian in that case because they're walking around with the order that gives them the full release to all of that. So all of a sudden, all that stuff gets to be brought into the equation, where if you had just gone straight to the courthouse, maybe it wouldn't have, right? So those are considerations to think about in any case. But the general rule is that judges like them. If somebody asks for one, usually I tell clients they're gonna get it. Let's just pick the who, right? Let's make sure that whoever we pick knows what they're doing and has a good track record of being thorough and unbiased, those type of things. Let's not just gamble on whoever they pick off the list. Let's spend our time there versus fighting for one. And again, when you get that recommendation, it is not to be disseminated because it is highly protected information. The parties usually can't even get a copy of it. Usually the lawyers get a copy of it and they can meet with their clients to discuss it. And you just have to know after reading it, good, bad, or otherwise, that's real close to what the judge is likely to do in your case. You know, I can count on one hand cases that we've flipped the judge on where they just thought, wow, the guardian really missed it on something, or they didn't address something that's really crucial and we need to add that in. Usually what you'll see judges do is little tweaks to a recommendation versus a complete overhaul. So anyway, guardian ad litem work is something that we do here. Again, one of, I think, the most crucial things that I do where I really have an impact on the lives of children and also assisting the court system, right? We want that system to be better and better every day, and we really have a fingerprint on that when we do guardian ad litem work. And so we keep getting asked in our our cases, right? Do we need a guardian? What's the pros and cons? Hopefully this video can help you chew on that a little bit more. And of course, your case is unique. You need to speak with your lawyer to make real legal advice. This is just kind of a general overview of the role of the guardian ad litem. Thanks guys for tuning in. We'll see you next time.